Okay, so welcome to eLaw. The purpose of this first tutorial is really, or workshop, is really just to talk about the scope of the subject, what we're planning to do, what makes it different, and really the thing that most people, the important thing that drives, the machine that drives the whole engine is assessment. What's the assessment and what's it all about? Okay, so the really simple potted version of what eLaw is it's a subject that talks about the impact of electronic media and electronic systems on the law. Now, once upon a time, this was a very, very popular subject and a very niche subject because computers were these things that sat outside people's everyday experience. It wasn't the days when everyone carried around a supercomputer in their pocket. A computer was a thing you went to from irregular times to look things up, and at some point it got connected to a thing called the internet. But back in the early days of eLaw, it was questions like, what if someone signs a contract over a computer? Is that really a contract or not? Now these days, basically everything is eLaw. Our entire culture, our law, everything is mediated by electronic media, and everything is digital, everything is virtual. So that puts us in a rather strange position, because in some ways contract is eLaw, torts is eLaw, criminal law has definitely got an eLaw perspective. And when I went to assembling the weekly topics for this subject, it was a very strange situation that a lot of the things that we're going to talk about are things that are covered elsewhere, either overtly or just implicitly. As a result, there hasn't been an eLaw textbook since, I think, 2011. The idea of teaching this as a textbook-based subject kind of became a little redundant as well. So my focus is to think about this as an opportunity to do a research subject, to take an area of eLaw that you're interested in and develop it. The assessment drives that. The assessment is focused on that. We still have the weekly readings, and the weekly discussion, the weekly study guides. Now, we'll be talking about those in workshops, but we're not going to be doing them in the same way we would if, say, it was a subject that had an exam in it. You're not memorizing these things or taking them away to, basically they're there, something to skim and to think about, and to talk about the issues that come out of it. So you're not going to have a situation where anyone is going to, in an exam situation, say, what was the Oracle decision about, and how does that impact on electronic contracts? However, when we read materials around this and we read stuff about the Oracle decision, we start thinking about copyright and contracts and so on, and how all that fits together. I'm also aware that when I was talking about the overlap with other subjects, we do have, and some of you have probably done, the intellectual property law subject, and until recently, eLaw, a lot of the eLaw textbooks are about half intellectual property. So it's kind of redundant again for those who studied IP law to study it again. And if you haven't studied it, well, if you're interested, we'll do a little bit of it, and you can probably do IP law or whatever. Look into it on your own. So let's get back to the assessment. The concept of the assessment is that you will be developing a set of resources or materials for the public on a particular area of eLaw. The two assessment tasks, one is a workshop presentation and paper, and that is going to be your pitch. That is going to be your research plan. It's going to have a look at an overview of the area, how you're going to go about creating your resource, what sort of things you're going to put in there, and that's what you share with the group. And the group, including me as a marker, gives you feedback on that and gives you some idea of where to go with it. Your second piece of assessment, and these are both 50% assessment, is the final product that you produce. And what we should be able to do is produce it in a wiki format. I say should because I've just managed to get a deal with Google Apps for Education. They've got a special deal where their commercial package, which is Google Apps for Business, which provides you with a whole lot of resources and interesting doodads. They're making it freely available for some educational institutions, provided you can convince them that you're legit and everything else. So I've just been going through the hurdles of saying, yes, we're real, and they've given me permission and they've set up an account for me, and now I've got to try to figure out how to actually use it. But it means, I don't know if you've had experience with wikis before, most of the free services like Wikia are full of ads, and they're really intrusive and they're really hard to manage, and I really think putting ads on an educational thing is kind of morally problematic. But what it means is we should be able to use Google's service to create a functional wiki where we can put our materials. It also means that as things evolve, there is potential for collaboration. So if people have similar interests, then we can link those interests together. And some of the basic decisions we're going to have to make is what are some of the categories in the wiki going to be? What are some of the top level categories that organise it? But within those, we may have an interest in something like electronic crime. And we could have a situation where someone says, well, I'll do 3 case analysis, plus I'll do a commentary on international crime, and I'll do this. And someone says, okay, well, you're doing something on international crime. I'm really interested in the Russian mafia. So I'll do a piece that links into that on the Russian mafia, and we'll connect that in. And you can then also connect out. So obviously Wikipedia is going to be something that you can link to, and you can have sets of and work in the same way Wikipedia does. We have a set of links out to other resources down the bottom. But I guess target audience is slightly different to Wikipedia. What we're kind of writing is another textbook. You're not going to be writing a whole textbook, but we're going to be writing pieces of a textbook aimed at people who are seriously studying law, not necessarily just casually looking things up on Wikipedia. So it'll have serious stuff in there and serious analysis. And part of what our discussion will be around tone. What is the tone you set for something like that? So that's the assessment in a nutshell. There's weekly readings and there's a weekly study guide with only 7 students in the course, although we might pick up another couple, who knows. I'm not going to be focusing on that in an intensive kind of way. I'm going to presume that you've read in terms of you've skimmed through and had a look at and thought about the ideas before you come along, but I'm not going to be expecting that anyone's going to have detailed knowledge of any particular area of law or case or whatever. However, what we can do is, if you've read things that you're interested in, we can pull those out and we can talk about them. And then we can focus in and say, well, okay, what does that mean? And when I've been selecting the readings for this, I've tried to create things that were source things that were interesting, which is not always easy with legal articles and things. But 2, they also sort of thematically link together. And they linked into some of the overall course concerns. So that's it in a nutshell. I guess I have more things to say, but I want to give you guys an opportunity to ask questions before we go on. My chat windows. Might get more students if they drop family law. Yeah, I could start a marketing campaign against family law that would go down really well. Yeah, there's this kind of thing where, and it even happened way back in the ancient days when I was in law school, where there was this presumption that you really did need to study family law just to be on the safe side, because that might be where you'll end up practicing. And it would be wrong for me to kind of scoff, because most of the work I've done through community legal centres has been family law. So I did actually use family law, even though it was one of the reasons why I stopped working for community legal centres, was because I was sick of divorces and child custody as the only things I was looking at. But the thing about family law is it's reasonably easy to pick up from the Law Foundation's handbooks and guides. I didn't find family law terribly challenging myself. Not that I got a fantastic mark for it or anything, but yeah. it's largely procedural, it's largely administrative, which I think is good because that's why it works. You don't want family law cases going to the High Court. You want family law cases not to even go to court at all. You want them to be resolved through mediation before any process happens, particularly when kids are involved. You don't want kids being involved in litigation. But anyway, but I can't, I know this is going up on YouTube and I'll probably, get some grief from whoever's teaching family law this term. But yeah, it's a different sort of audience, I think, too. And I think if you're interested in something that's a bit of a challenge, and this is, and I don't mean that as in a scary challenge, but a challenge to sort of really think about the area of law and to draw connections between lots of areas of law. I think this is a more interesting subject. But then again, who can say? And I haven't seen the numbers of who's enrolled in what at the moment. And as I said, CQ doesn't close down courses for low numbers, so that's good. That gives us a nice small group to work with. I'll probably get grief from the dean in terms of how many students I'm teaching, and you want me to take more courses or something, but that's a completely irrelevant issue. Okay, any other questions?
I have a... Hello? Hi?
Yeah. I can hear you.
Oh, you can hear me, okay.
Yep.
I think just reading through, I guess, the week 1 notes, as well as the general, I guess, topics that we'll be going through, I can see that things like, so I'm particularly interested in digital technology contracts, and whether that's the week that I nominated for anyway, and whether, I guess, when you click here or when you send your electronic signature on a PDF document, whether that is binding or whether it's as good as a wet signature. But more so as well, and I don't know where it fits, more and more we're getting things being issued by email because it's easier to package and zip file and send something. So pleadings, documents, briefs of evidence, etc. But what about service of documents? And there's some reading I've done on New South Wales Supreme Court decisions when it comes to construction matters where the service of a claim, where the Act stipulates it could be hand delivered or faxed. I can't fax anybody from where I am. I'm in 2015. So is email acceptable? So I think e-law is probably going to evolve a lot faster than, e-law needs to evolve a lot faster than what it is, because a lot of legislation is kind of trapped, and a lot of dealings are still 10 years ago in the way things happen, but everything's evolved a lot quicker. I can switch from my laptop to my iPhone to my iPad and you won't know, and it'll just seamlessly transition across.
And that's one of the things I've really noticed, because I did some work with the Communications Law Centre way back when I was at VU. Terms and conditions and the way terms and conditions operate, and particularly click-wrap contracts, have evolved so fast that what their legal meaning is, I find fascinating, because we assume that when you sign up for a new version of iTunes, for instance, you download the updates, and it comes with an attached 20 pages of terms and conditions, and you click on to say, yes, I have read and accepted them, that's legally meaningful. Now, I understand how the context in which this came out of. I understand that there is a certain kind of, you've done equity, I guess. You know the difference between equity and common law. There's kind of a common law logic to it that basically says it's in the contract. If you haven't bothered reading the contract, that's too bad. If you signed it without it, that's too bad. But from an equity point of view, there's a real sense at which, well, where's the power imbalance here? And the power is all with, Apple, who are giving you the new iTunes, and there's a certain sort of consumer power imbalance. And lots of consumer laws step around contracts, and they step around offer and acceptance, and they say if it's a consumer, if it's a commercial contract, yeah, do your worst, because if you're a business, you should be reading everything. But on consumer contracts, it's quite different. So in terms of that evolution, that's something that's fascinating in terms of where we're going, in terms of, well, what do you accept? How valid are those click-wrap contracts? What happens if, I wouldn't recommend anyone necessarily watch it without warning, but the South Park episode of the Human Centipede, where you basically volunteer to medical experiments by ticking on the latest iTunes, and then when people say, I don't want to be experimented on in particularly grotesque ways, they say, oh, but you signed the contract. I mean, that's a silly example, but it's a concern a lot of people have. And I know Facebook, for instance, is constantly putting strange things around privacy and intellectual property in their terms and conditions. And then you get the weird Facebook postings of people saying, don't post things on Facebook because you'll lose all your IP, and then that goes viral, and then it all goes on. So I think that area of the legal meaning in that and the new environment is really, really interesting. And we will probably see a high-profile case of some form or another before too long.
The other interesting thing that I've been doing since doing IP law with yourself last term is going to my messenger apps on my phone, particularly WhatsApp. And I actually spent an hour reading through their terms and conditions today. Don't ask me why. I just was having a debate with my wife about it. And I read through, and I got to the part where it says that you hereby grant WhatsApp, its affiliated entities, etc., completely royalty-free, non-exclusive, sub-licensable right to distribute, reproduce, sell any of your status submissions, photos, videos, whatever.
Yeah.
And that's shocking. And the point that you make about not reading the terms and conditions, going back to my contract law training or study, Lestrange and Graucob. If you haven't read the terms, that's your problem, pretty much. But is it a reasonable expectation for somebody to read through 20 pages or 20 screens of terms and conditions? And when you go back to your foundations of contract law, I think there's I think it's Thornton and Shoelane, one of the cases there about terms and conditions. If there's something so onerous, you must put a red arrow or must highlight it, point out that this is an important term. In a lot of electronic contracts or terms that we'll go through, we don't do any of that. We just go, by clicking here, you hereby accept, just take me to the next screen. Come on, I'm done.
Yeah. And a lot of them even are online too. They're not actually contained in the thing you're agreeing. They'll just say, for your terms and conditions, see this website, which adds another
Correct.
Yeah.
I'm going to say, what if you don't have access to the internet?
Interesting question.
Because I recently had a construction contractor say, can't I just put on the back of my invoices, this invoice is subject to the terms attached to on our website. If you by paying this invoice, you hereby accept and acknowledge these terms. And I said, oh, that's a tough one, because what if you update your website or you change your terms, and you can't introduce new terms after consideration's been paid? That's already established. And he's like, well, but this is a new era.
Mobile phone contracts are classic for that, aren't they?
I hate yeah. That's why I pay month to month.
No, this is good stuff, and this is conceivably what a chunk of what we do in terms of the wiki would be around electronic contracts, and there's certainly a lot of stuff on licensing, and I know more about it in terms of IP licensing, but there's been an attempt by the creators of CAD, Autodesk, to say that what we're doing is no longer selling software. What we're doing is granting you a short-term license to use our software for various reasons involving particularly the second-hand market and their attempt to control the second-hand market. And a lot of that then gets back to, well, what if what if the contract says you're not buying a product when you buy software? You're just buying a short-term license. What does that mean? And, you know, it works in other areas. When you go and see a movie, you're not buying the movie. You're buying kind of a short-term license to watch the movie once. What does that mean for electronic versions of things? So, yeah, while most e-law has become everyday and sort of mundane, there's all these really interesting questions that are just sort of in the too hard basket. And that's good. It's good for us.
That's an interesting point you make about the short-term licensing, or it's like they call it. I know what you're talking about with AutoCAD. It's called AutoCAD 360, which is much like Microsoft Office 360, where you're buying an annual subscription or an annual right to use the software. After that time expires, you don't actually lose your data. It just becomes a read-only. You can't modify it unless you purchase a new license. Because people were on-selling these licenses. They were writing it down, getting their tax deduction, and then selling it. And selling it with their computer or something like that. So people were... in the past, the company I worked for bought a second-hand AutoCAD license because it was 2 years old. It was cheaper than buying the brand new software. And I myself use an accounting software called Silk, which is a month-to-month package. And what they say is if you must actually resign your license is in the terms and conditions. So I've got to give them 30 days notice saying that I don't want to renew for the next month. So please stop debiting my account. And then they will actually convert my file into a data file, which could be read by MYOB or Xero or something like that. But it will cease to be an active Silk file. And so its proprietary, I guess, coding that's attached to that file will be stripped out of it. So it'll still have my raw numbers, but how it classifies things will then be removed. So I don't really own anything. I'm just, I think of it, I'm just like hiring a car for a day. I've got to give it back.
And we kind of do that anyway, even with software, because unless you're going to keep that old Windows 95 computer operating that has your old versions of Word for Windows 95 working on it, you can't keep using the old software anyway because the hardware updates. So effectively, I mean, you could be really stubborn, and I'm sure I'm sure our university has people running Windows 95 computers in it somewhere, you know, and you could, you know, but you're not going to be able to, you know, send your files to anyone else, and you're going to, you know, they're not being able to connect to the internet or anything else with it. But we already do kind of have that redundancy within that sort of idea of ownership. So the idea of what you do when you interact with software, early on we went for the purchasing a product metaphor. And with cloud-based systems, we might be moving towards purchasing a system, purchasing access to a system. So the lore of that is really quite interesting. And, you know, sometimes you can see the interests of the software sellers in that it's reasonable from their point of view, and sometimes it's completely unreasonable. AutoCAD had a term in it that said you weren't allowed to physically move the copy of the software outside of the jurisdiction you bought it in. It was actually one of their conditions in their licensing agreement, which in Australia is one thing, because, you know, the effort we have to go to move outside our jurisdiction is much higher. But can you imagine living somewhere in Europe and being mobile and being told, oh no, you have no right, you've bought AutoCAD, but you have no right to use your software in the next country, which is, you know, just down the road from you. So as always, there's a real balance of interests that go on there. So anyway, yeah, that's certainly a topic that I think is interesting. We could work on. There was something early on, you mentioned, going back to service of court documents, someone being served over Facebook. I don't know whether that was just an urban legend or whether it was something that just got reported in things like MX, or whether a judge at some point actually allowed that to happen.
A judge actually allowed it. It was to that footy player who went and played for the French club.
Okay.
It was actually, he was served over Facebook, and it was a subpoena was a subpoena actually.
Okay.
So he wasn't
There you
served
go.
documents per se. It was just a subpoena
Okay.
saying that you. And I
suppose
don't know.
it was served by
I'm going to look it.
fax.
I'm going to look it up. Actually, I might post it to Moodle. I'll try and find it.
That'd be
But
awesome.
to my understanding, it was a post on his page which said that there are court documents which we need to serve on you, and we've been granted permission to post on this page that you are required to attend court on such and such day, blah, 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 blah. Because it was found that he was using Facebook. It was a reliable method of contact, and it was proven that he was the account holder.
Okay.
I'll try and find the article as well that said it's such a farce because a lot of celebrity or popular sports person accounts are managed by their management team, not by themselves. There's an administrator who's appointed to it. So, and some of it can be automatic. And there was a case of one female American actress who passed away just before the Oscars last year. And then after the Oscars, there was an automatic post that said, congratulations to all the, like the winners, And it was a tweet from her. And it was just a robot who produced that, not anyone.
Yeah, okay. Interesting stuff. Because quite often then you've got to dig back to what the original intent, particularly things that have got legislation and so on. And as you said, if you've got things that you can send to a fax that may not have anyone answering it or may not be plugged in, what other, how else do you, how is that different? How is it similar? Anyway, lots and lots of interesting topics. The advantage of not having an exam in this is we don't have to cover everything evenly. I'd like to make sure that from a week-to-week basis, you come out of the course with at least a familiarity with the issues that come out of each week. I mean, I've got no way of sitting there and forcing you to do the reading each week, of course, except that, except for my promise that if you at least put the effort in at the front, you'll start making those connections and you'll start seeing how those issues join up. Even if every particular little piece isn't fascinating to you, at least get a passing knowledge of the sections. Now, there's a bit to think about, and I'm not going to. I'll probably do a little bit of firming up on the assessment support materials. I'm not changing the criteria or anything because I can't, because that's all set down now. But what I'll do is once we've got a better idea of what you aim to do, and I've got a better idea of how this new Google App stuff is actually going to work, if it's going to work. If it doesn't, we'll find something else. Then I can start sort of creating more guides around the assessment that say this is the sort of things we expect, this is the sort of format for it. But that'll be done collaboratively. That's not like a fact that I'm just going to come in and, change everything. That'll be a case of talking to the group and finding out what things you need. Probably more structure where there's lacking structure there at the moment. But that's reasonably easy to do with 7 people, or 2 people for that matter. Okay, so
given that there is 7 of us, is it unlikely that you'll permit us to team up on the weeks, or would you prefer us to be a separate week each, since there's only 7 and there's 7 topics?
Yeah. It's probably best to spread it out, but I don't think it matters.
Okay.
Because at some point we may find that the presentations and the weekly topics become unstuck. And I don't really have a problem with that. So
become a what, sorry?
They become unstuck. So there might be a point at which, just say everyone's really interested in licensing and contracts. We might end up doing 4 weeks on licensing and contracts, just with 4 people looking at different aspects. So I don't think that's a problem. And then we just keep the reading going along in the background. And if people, and we mention it from week to week, and if there's anything interesting, someone says, "Hey, I thought this was interesting," and that connects to that, I think that's fine. But yeah, we're not sort of pigeonholed into that strict structure as we would be if we had 90 students in the subject and limits on, you know, who could do what when. In fact, one of the students has said to me that she works night shifts all week from like 4 o'clock to 11 o'clock, which must be joyous. And I've said, well, we can do it asynchronously through, as long as she'll have to be a bit more proactive about what she does, but she can create a video, she can post it, we can put a discussion forum up there, and we can give her feedback through the discussion forum, and we can do it asynchronously. And likewise, she can view what we do from week to week and put comments up asynchronously as well. So trying to make this as flexible as possible for as many people as possible, but also realising that if no one shows up from week to week, it's going to be, or few people do, it's going to be pretty dull for those that do show up. So try to make the balance there. Yeah. So we reasonably happy with what the big picture is?
Can you hear me?
Just vaguely.
Sorry, I have no idea where the microphone is on this.
That's good. That's good.
Sorry. Yeah, no, that's good. It'll be, I suppose I'm just waiting to clarify exactly what you'll expect of us for the workshop.
Okay.
Just because I nominated to go in week 4. So, yeah, that's all.
Week 4, which is week 4.
Digital identity or authentication.
Cool.
Yeah.
Yeah, so basically, the way I see it, and as I said, this is something that's open to collaboration. The way I see it is that you might have like a 10-minute spiel prepared as to what an overview of the area, and it's basically a pitch for what you're going to be working on, what you plan to be working on for the resources you prepare. So the assignment is not a large number of words. It's 2,000 words. I'm asking you that because my brain is fried. Been dealing with complaints and all kinds of things all day, and doesn't seem to be.
Yeah, it's 2,000 word paper with a 500 word reflection.
Yeah, and we can. If you haven't done reflection before, we'll do a little bit on what that means. So really, we're probably looking at, if we're looking at like a wiki, maybe 4 nodes, 4 pages of information for a wiki. So part of your proposal is this is what I think the central topic is, and these are the nodes that I want to create. And of course, there's no limit to a wiki. It could be a paragraph. An entry could be a paragraph, or it could be longer. But it may be, and this is just the way I'm imagining it, that you have your main topic as a couple of paragraphs, and that links into maybe 4 other pages, each of which has discussion. So one page might be an analysis of the legislation. Say the Australian legislation on this is this. Here's the links to the different states. Another page might be linked to a case. This was considered in this case, so on and so forth. And this is this is one thing I am interested in developing here, is the different skills you need to write in a wiki format, because wikis change over time and they evolve over time. So you're writing with the idea that more links will be placed in over time. And if you put a phrase like terms and conditions, for instance, into what you write, even if you don't link it, if someone else writes a page called terms and conditions, the wiki will go back and link that page, hyperlink that page into what's written. So it's a different style of writing. But if what Richard Susskind tells us is true, and he makes a very convincing case in Tomorrow's Lawyers, this is the sort of thing lawyers will be doing in the near future. You certainly won't be writing assignments. I can promise you that. You'll never get an academic job. You kind of write assignments because you write papers, but no one ever in the workplace says, "Go away and write me a 3,000 word essay on this," and no one asks you to write an exam. Shockingly enough, I did enough of them, and I've never had someone sit down and say, "Now sit down for 2 hours and write down everything you know about that area," and no looking at any books or talking to anyone else. So, or maybe you've had a different experience with that.
Oh no, I'm studying advocacy as well, and in parallel, one of the notes or one of the aspects that's in week one's advocacy notes, is that there's a greater emphasis on written submissions than there is on oral arguments now. And
Really?
courts and tribunals are focusing on written submissions, because I suppose you could stand up in court and argue for days on end, whereas if you submit a succinct 50-page document,
Yeah.
the magistrate or the judge will be able to read those, I guess, points of claim and points of defence, and get a preliminary guide as to where things need to be. I was in NCAT today on a building matter, and that's what it's as if the member didn't really want to hear oral arguments. He said, look, I'll give you 3 weeks to make points of claim, and then opposing counsel, you can have another 3 weeks to make points of defence, and then we'll come back after that. And if one of you's, taking us on a frolic, you'll pay the other one's costs. End of story.
Yeah, I guess that's true. And if you think about it, most civil matters settle. So in most civil matters, you never, ever get an opportunity to speak to them anyway. It's all about the strength of what you've produced and whether you can actually play chicken with the other side and costs and everything else. And they back down and go, oh, it just looks too good. We'll settle. Yes, the people who study law because they want to be like the lawyers on TV and give emotional speeches to juries and things. Those days are well over, I think, or largely over, except in really, really high-level matters that go to things like the High Court. I know one of my colleagues, it's just how sort of switched off law study was in my day, turned up at the magistrate's court with a pile of law reports, Commonwealth law reports, and the magistrate just laughed at him and said, This is court. We don't care about law reports here. We don't care what the appeals court had to say. Just tell us what happened. So a lot of the mythology of what you think you're going to end up doing, you don't end up doing. And again, what Susskind tells us is that those conventional law jobs, being a barrister-style lawyer or a solicitor-style lawyer, are almost gone. They're on their way out. The profession is shrinking. But it doesn't mean that that's gloomy, because it means there are new and different things that lawyers are going to need to be able to do. There's a whole series of them, and one of them is design information and resources, particularly with the idea that people are not going to be able to afford individual legal advice on things, and they're going to increasingly be accessing online information and providing a way of filtering credible, believable, realistic information to people is so important now.
On that note, you should check out a website called thelazylawyer.com. I think it's thelazylawyer.com. I think it's .com.au. Lazylawyer.com. It's done by a girl who graduated the lazy law.
The legal world.
Sorry?
The
Robin Hood of the legal world. Yes. She graduated law school at Sydney University, and she worked for a top tier, I think, and said, this is ridiculous. I'm not going to be doing 70 hours a week. So she went and created this website where she sells some pretty decent precedents for you to, like basic contracts, will kits, marriage and divorce. She even sells the 50 Shades of Grey contract. Bless her.
I just saw that. Awesome.
Yes. I used that in my legal conduct assignment last year, which, much to Professor Colburn's delight, I believe. But these are this is really clever work that she's done.
Yeah.
In my opinion, it's very clever work.
And a great example of how things are changing.
Yes.
Yeah, again, the digital world's really led that. There's this expectation that things are going to be free, but also this idea that then you pay for when you need to pay. So things like basic legal advice probably should be free or really low cost. But then when you get into trouble, that's when you need to be able to hire someone who's really competent and knows what they're doing and is an expert. This is what Susskind says. And basically the large sort of area that's of semi-competent lawyers that have had an income for many years has disappeared because people don't want to go to semi-competent lawyers. They want to find out the basics just now, and if they are going to have to litigate, they want the best experts to do it. They don't want sort of to muddle through. So, yeah, thanks. I will use that as an example. And I'm actually talking about law textbooks on Friday to the Australian Law Teachers Association, because my argument is that textbooks should all be free and that publishers should invest in value-added services that people would basically, you can get into all the material that's currently in textbooks for free, given that most of the content is actually public information anyway. But then publishers should be looking at value-adding other services on top. So quizzes and feedbacks and personalised service, all those things are things that people could pay a subscription for without having to pay, $160 for a huge tome that honestly no one's going to.
$250 for the advanced stat text.
Wouldn't be so bad if the writer saw more of the money from it, but even the authors don't see any of the money from it.
It's probably got some very practical uses in practice down the line, but it's still quite a lot of money to shell out in the first instance. So
it'll make a good paperweight.
Yeah.
I've got a whole shelf. I've got two cabinets of paperweights that we could use if you really wanted.
Yeah.
But,
and it is frustrating because, you download everything, on your iPad and whatever. You read magazines on your iPad, read books on your iPad, and then you have to go and buy a ridiculously overpriced textbook to gather dust somewhere later, rather than just being able to see it online.
That's out of date before it's published.
Yeah. Yeah.
Well, one of the things Professor Colburn sold me on was iTunes U, and downloading all the notes and materials on iTunes U. Okay. And sorry.
It's all right.
And it's my daughter. I thought it was a really good idea that we could get material on the iPad, but then we can't take it into the exam. So what's up with that?
Yeah. So,
yeah.
And that's what I thought as well. Yeah.
I've been trying to make inroads into the bring your own device exam things, but CQ is kind of a little behind the times on that, unfortunately.
Look, I think if CQ staff were administering the exams as opposed to the team of highly talented invigilators that we get, it might be a little different because you guys might understand why we're there, what we're bringing in, and as opposed to one lady asked me if my watch was smart in the last exam. And I said, you mean a smart watch? Yeah, I know. I said, did you mean a smart watch? She said, yes. Can you receive data on your watch? I said, not if the phone's turned off. Then it's just a watch. She said, could you take your watch off? I said, no. And I had to explain to her that there's no connectivity between my watch and my phone.
Yeah.
That was an interesting conversation.
This is one reason why, and I know there's pros and cons of both, this is one reason why the law school uses take-home papers as much as possible, because of basically the extra problems that come as soon as you start involving other people in the process. And I know take-home papers are not ideal, and a lot of people just, stay up for 24 hours and burn out on them, where if they did a 2-hour exam, it'd be over mercifully quickly, one way or another. But yeah, one of the reasons why we're pushing for take-home papers as a format is because we lose control of the whole process as soon as it goes out the door. But we also have to be really careful because we have the accreditation boards hanging over our shoulders, and at some point they're going to say, how do you know students aren't just paying someone to write all their assignments? So we've got to come up with a convincing answer to that too. Yeah. You may have seen there's been a little bit of controversy on Facebook about participation marks and so on, and there's a group of students who think that they shouldn't have to participate. And unfortunately, the danger that hangs over all of that is if they have their way, it may mean that the law program just gets disaccredited, and no one can get admitted at the end of the day, which I don't think is what their objective is. But they just don't seem to be clicking to the risk that's involved. I don't know. Outside of the scope of what we're talking about.
In response to how do we know that students aren't paying somebody to do their assignments? It's because we've got no money after paying for the ticket.
Brilliant. I will use that one. Yeah.
It's not entirely out of, because that comes down to, authentication methods and how are we genuinely authenticating people online. And it's, I work for a government department where people are logging on to our online services to use them, and there's this notion that they're not allowed to share their password. No one else should have access. They all come in and do it for each other. And, it's interesting. Some people come in and they're so worried about their privacy, yet others just hand it out to everybody. So it's interesting. That's why I want to look at that stuff.
Yeah.
The regulation, but the technical, like the IT side of it, it's meshing both of them together, and how they can work together is tricky.
Fantastic. And if you can draw on your practical experience through any of your study, that's brilliant. And that's something I'm really in favour of. Because you can learn so much more from something you know something about than a hypothetical, case study about hypothetical people doing hypothetical things. Yeah. So I'm really happy with that. Okay, well, we're heading into sort of the last bit of time. Any other questions before we close up? So we'll see if we have more takers next week.
Hopefully.
And if not, hey, we'll create some interesting things and put them out there and see how we go. If at the end of the day we don't end up creating a wiki, we go for another option, then that may be what we end up doing. And that'll be cool as well.
Yep.
Okay, guys. Well, have a good evening.
You too.
Take care of children and pets and the various creatures that have been collaborating on them today.
Yeah.
And I'll talk to you all next week. Oh, that is so adorable.
He is. Yes.
Is that a Frenchie?
It is, yes.
Oh.
Yeah.
Yes. Yeah.
It says happy birthday all day.
Okay. Oh, there's mine. He's out of the room. I've got a great.
Do you wanted to say bye to everyone?
Bye.
Sorry, Scott. I think she called you Santa. Sorry.
Bye.
Bye. See you next week.
See you, everyone.